The presentation is being recorded, so please click on the pop-up to acknowledge and accept. We also ask that you please keep yourself on mute. The presentation today is meant to help small landlords understand the value of mediation, learn how to engage their tenant in meaningful discussions to resolve issues, and look at the procedures in place at the Landlord and Tenant Board. This presentation offers general information only, not legal advice. There will be a question period at the end of the presentation. We will be answering the questions that were sent to us by email, as well as live questions through the chat function. My colleague and fellow community legal worker at Landlord Self-Help Center, Diana Pedierna, will be monitoring the chat and assisting with the question period. What is mediation? Mediation involves a dispute resolution officer who works to help facilitate discussions between a landlord and tenant. This is a voluntary process, which means that it will only go ahead if both parties agree to try to resolve their disputes with this service. This process can be very beneficial for small landlords, as all issues are on the table. This means that issues which are not directly related to the pending applications at the Landlord and Tenant Board can be discussed and potentially resolved. The mediation and dispute resolution services are free services offered by the Landlord and Tenant Board. The DRO officer is there to provide information to the parties about their rights and responsibilities under the Residential Tenancies Act and facilitate discussions about unresolved tenancy issues, not to provide legal advice. If there's any possibility that the landlord and tenant may come to a resolution with the assistance of a DRO, this option will help reduce the amount of time you're waiting for your matter to be heard and increase the likelihood of a faster resolution to your application. The new Tribunals Ontario portal, which was launched on December 8, 2021, now allows one party to send the other party a message through the online dispute resolution portal. Mediation can take place prior to your hearing by contacting the Landlord and Tenant Board directly or requesting it through the new portal. If the parties are able to reach a tentative agreement and need help finalizing it, they can press the Agreement Reached button shown in the portal. They will then be connected with a dispute resolution officer who will review the agreement and send necessary documents for signatures. This online dispute resolution tool on the portal provides opportunities for the parties to hold settlement discussions and request the assistance of a dispute resolution officer for mediation or to finalize a settlement agreement or obtain a consent order. What happens after mediation? So if the parties are unsuccessful with resolving their issues through mediation, the application will proceed to a hearing and anything discussed during mediation cannot be mentioned. In addition, disputes that are not part of the applications filed will likely not be heard or considered during the hearing if the necessary paperwork has not been previously filed. If the parties are successful in reaching an agreement during mediation, a written agreement will be prepared for you to sign and the hearing will be canceled. It's best not to leave with the handwritten document. Ask the mediator for a consent order. In some cases, the agreement may even involve ending the tenancy on a specific date. As a side note, outside of the mediation process, if the parties are able to discuss and come to an agreement to end the tenancy, they can complete and sign Form N11, found on the Landlord and Tenant Board's website, and submit it to the Landlord and Tenant Board to have an order issued. Recent changes to the Residential Tenancies Act by Bill 184, the Protecting Tenants and Strengthening Community Housing Act, now allow payment plans to be made for rent owing, and these plans can become the basis of an order when filed with the Landlord and Tenant Board. This change means that the alternative dispute resolution services and community mediation not previously recognized by the Landlord Tenant Board will now play a greater role in assisting parties to reach agreements and develop payment plans. In this case, the payment agreement and advance resolution request forms from the Landlord and Tenant Board website can be completed by the parties and filed with a pending L1 or L9 application, or the parties can go through the online dispute resolution process on the new portal. This is a snapshot of the Landlord and Tenant Board payment agreement form. Another change brought on by Bill 184 is the power of the Landlord and Tenant Board to refuse to order eviction for non-payment of rent if the landlord cannot demonstrate their attempt to negotiate a repayment plan for arrears with the tenant. This provision came into effect on March 17, 2020 through Section 83, subsection 6 of the RTA. This provides even more reason for small landlords to enter into meaningful discussions with their tenants in an attempt to settle the issues and work out a payment plan. Now I'll pass it over to Mary Chum and Benjamin Vanderwent from TNG Community Services, followed by Jennifer Lam from York Region Community Mediation Service to talk more about conflict resolution and training and their services. Mary is a student at York University, completing a social work major, and Ben is a second-year law school student at Osgoode Hall Law School. Mary will be providing an overview about TNG Community Services and what they have to offer, while Ben will be speaking about conflict resolution techniques. Mary and Ben are both interns with the CRT. Jennifer is the coordinator of the York Region Community Mediation Service and the current vice president of the Ontario Community Mediation Coalition, and she will speak about how to access their sibling services across the province.
I'll just be sharing my screen right now. Does everyone see the full screen?
Yes.
Yes, okay, that's great. Hello, as an introduction to today's presentation, we will be delving into community resources and inform about conflict resolution services that are done through mediation, as well as tools to help you communicate about things that are causing conflict. We will look at the ways conflict is created and the ways we can minimize disagreements to help have a more productive conflicts. So what is community mediation? Community mediation involves people coming together to resolve their own disputes. If parties are willing to come to the table, 80% of the time, they come out with an agreement. Those agreements last because the parties come up with solutions together, as well as having mediators there as a neutral third party to help guide the conversation and create a safe space for discussion. The process of community mediation addresses the communication gaps between parties. Free, voluntary, and confidential are key concepts to make this work. So the mediators we have are experienced volunteers and work in pairs. And here at the neighborhood group, we do co-mediation. So communication is a necessary part in community mediation and addressing the conflict or particular issue. Conflict creates change. So you can have respectful and relatively peaceful conflicts, as well as the conflicts that bother most people are the ones that they are passionate about, arise from anger, or where there's a taking on a particular stance of a situation. So communication, community mediation focuses on developing skills for communication and productive conversations, finding active listening as an essential part, and learning how to de-escalate conflict. And I'm sure everyone has had a time where they weren't sure how to address conflict or manage the emotions they had. And in some instances, individuals I have talked with mentioned that they were uncomfortable or were not sure how to approach someone, for example, their neighbor. So mediation helps establish this and alleviates this kind of barrier and creates a safe space for discussion. And community mediation helps resolve conflicts by changing the way people communicate. So the question is how well. We decided to find out. So funded by the Law Foundation of Ontario, our new research report was developed with the Winkler Institute for Dispute Resolution, and we surveyed participants of community mediation across Ontario. And the results show that community mediation is an effective method to resolve existing and future conflicts and disputes. So on average, 64% of people surveyed did use the skills gained in community mediation. So what we do mediate, we do mediate neighbor to neighbor disputes. This can be anything from fence disputes, property lines, noise disputes, pets, parking, as well as shared space. So that can be a shared access area or pathway. We do family disputes. So this can be between siblings, parents, and roommate conflicts. So as the housing crisis in Toronto deepens, more people are finding that they need to share accommodations, and this creates points of disagreement in the shared space, and as well as trying to find a way to de-escalate that conflict. And then we also have tenant and landlord disagreements. So especially in a rooming situation where the landlord tenant board cannot be involved, but also rent, and there are maintenance issues. There may become conflicts that arise as small landlords trying to address the relationship between tenants or behaviors. And we also do mediation for volunteer community groups. So that can be faith organization groups, special event plannings, tenant associations, and the internal conflicts that occur during there. And we do get court referred cases. So that can be peace bonds, assault cases, or harassment cases as well. So what we do not mediate, in cases of separation cases, we only mediate those if they have already come to an agreement before. We cannot be involved in deciding on the agreement or modifying it, but we will assist in child transfer or communication with services. We also, for our workplace disputes, we do not handle that, but we do mediation for that on our social enterprise side. And we do not do violence disputes or anything surrounding domestic violence. So we also do not mediate conflicts involving people with mental health issues who are not stabilized or without supports. Another aspect is good faith. So the individual's intention or purpose to participate in mediation, their capacity to mediate, and to follow through on the agreements. So these are the kind of steps to mediation and how it kind of looks like. So there are 3 sections. The first one is intake. And what intake is that our case managers will be there to gather the basic information of both parties. And we kind of assess whether they're willing to participate and hear both sides of the story. And if both parties are willing to mediate, we go to case development. And case development is individual meetings with each party with our co-mediators. This takes about 1 to an hour and a half. And then mediation that occurs after is sectioned into 3 phases. So the phase 1 is mediators elicit each person's story and develop an understanding of each party's concerns. And in phase 2, also in phase 1, we happen to have a chance for parties to share with one another what the other party hasn't heard yet. In phase 2, mediators help the parties to understand one another's needs. And in phase 3 is where we develop a mutual agreement and kind of goal setting that is mutually beneficial for both parties, is what we hope to achieve. So to make referrals, we do have 5 catchment areas. So it would be North York, downtown, York region, Dixie Bloor. And we usually take during the intake is the client's name, phone number, address, and email. And then we do also ask for the second party's information, as we do need to see if all parties are willing to mediate and are based upon the element of it being voluntary. And also Warden Woods is another catchment area. Yep. And for workplace and organizational services, so CRT does offer as our social enterprise business with its earnings going back into TNG Community Services involving the free community mediation program. So in the workplace organizational services, there's a place for you to register to learn about subjects about managing conflict, series that are specifically for supervisors or managers. And we do include training on topics of de-escalation, mediation, and communication skills. And you can currently find all of these information and offerings online. and we do customized services for business or workplace. So here's our referrals, where you can call if you have any questions or concerns or inquiries about our services. This will also be shown at the end. And now my coworker Ben will be talking about navigating conflict.
Thank you, Mary. So yeah, I'm now going to be talking about navigating conflict. Another service that the neighborhood group offers beyond mediation is we offer conflict coaching. Conflict coaching is often very applicable when either one of the parties is not willing to mediate or someone just wants to improve their communication skills in preparation for a hard conversation or just in general. So yeah, we're going to start a little more abstract with just what is conflict. Yeah, conflict is the friction that results when the beliefs or actions of one person are resisted or found questionable by another. And it's important to know that conflict is normal. We have conflicts every day. It's a part of living in community. We can have conflicts within ourselves, with other people. We have them with our partners, our friends, our coworkers. Anytime we're in a relationship, there's potential for conflict. It's important to know that conflict always requires two or more. It's impossible to have conflict by oneself. And so it's important to realize our own role in it, but then also how we can address it to help the conflict be a healthy conflict and not a toxic one. So we're going to move to the next slide now. And there's several different conflict modes that are quite common. And so you see there's two axes here. There's on the y-axis, there's assertiveness, and on the x-axis, there's cooperativeness. And ideally, in most situations, we want to work towards a collaborating mode. Collaborating is when we are thinking outside of the box with the person that we're in conflict with. And this is often the best because it often allows win-win outcomes where we each get to serve each other and help each other reach our interests. But there are other types, and different situations require other types. So you see on the upper left, we have the competing mode, which is often a zero-sum orientation. And this is very applicable and actually encouraged in some situations like military or emergency personnel, where decisions need to be made quickly by someone in authority. Likewise, on the bottom left, we have avoiding, where in some situations where, let's say, the party is unstable or dangerous, it might be better to avoid the situation or to withdraw. Or in the middle, we see compromising. And this is also applicable in situations where there are external factors that are limiting the creativity or the cooperative amount that's allowed. And lastly, on the bottom right, we have accommodating, which is low assertiveness and often results in one's feeling of not feeling respected or heard. So like I said, in a lot of situations, we're trying to move towards the collaborating mode. So high cooperativeness and high assertiveness. So ensuring that the other party knows what you're hoping to get out of it, but also making sure that you know what the other party needs and helping them get there. So now we're going to talk about how to get there. We need to know what to avoid. So what goes wrong in conflicts? Often there's several things. People talk at each other instead of to each other. And this ties right into number two, is they don't listen. It's really difficult to listen in a way that we actually understand what the other person hopes to get out of this. That is really crucial to having good cooperation. We are often more interested in defending our positions rather than hearing the other person. When we enter into a conversation, thinking about what we hope to get out of it, it's like a mental barrier for listening. Like we just aren't able to hear what the other person is hoping to get out of it. And so if we can find ourselves moving towards an interest-based position where we're walking to this conversation, really hoping to learn how we can help the other person, it's amazing how often that mindset will actually kind of superimpose itself on the other party where they suddenly want to help us and we're helping each other. That is only possible if we let go of our ego and our pride. And of course, if we avoid escalation. When things escalate and our temper rises, then our reasoning decreases. And so that just never leads to a good, reasonable outcome. So moving to the next slide, our goal is to alter this pattern. So I'm going to talk about two different techniques, how to do this. But in general, we're trying to move from blame to consideration of your own role. Conflict always requires more than one person, as we mentioned before. So it's important to take responsibility for your part. Second, we're moving from certainty to curiosity. This is the interest-based. Third, we're moving from blame to empathy, trying to understand what's driving the other person. Fourth, we're moving from passivity to assertiveness. And like I mentioned, it's important that both parties know what's driving the other party. And that's the only way we can come up with a good solution. And lastly, again, move from positions to interests. So we're going to talk about a couple specific examples and just a brief outline of how to think about it. So in a conflict, there's an option where they approach you. And if you decide to talk to them, there's a couple things that you need to do to prevent escalation. And I just want to stop there and point out, like, if you decide to talk to them, it's really important that when we have conflict that we're in a good, healthy headspace. And if we're not, it is so appropriate, and we encourage just saying, hey, I think this is an important conversation, but can we talk about this next Wednesday? For whatever reason, if you're not in a good headspace that day. But once you guys are talking, if they have approached you, then first just listen to what they're saying. And second, acknowledge what they've said. And acknowledge it is often helpful to kind of repeat it back to them so that they really know that you understand what they're hoping to get. And then only after listening and acknowledging and making sure that you know what they're hoping you know, and then you move into telling them what you want them to hear from your position. And so the next slide talks a little bit more about focusing on the interests when listening. So when our positions are the part of the conflict that's visible right away, they're often about what the conflict is or seems to be about on the surface. As you can see in the iceberg on the picture, it's kind of above the water there. But these positions are supported by interests, which justify and explain each other's parties' positions, at least in their own minds. And our interests are about what we hope to achieve through our positions. And so when someone approaches you, it's really important to take note of their position, but also what's behind their position, what they're really hoping to get. Are they scared? Are they feeling vulnerable? And those things kind of help us empathize. And the second thing we're going to talk about, kind of a technical skill in the next slide, is how to start a conversation. So on the other hand, instead of being approached, you want to approach them. And it's the same initial starting point. Make sure that you're in a good headspace, that you're feeling healthy, and also respect if they're not. If they're feeling really stressed or whatnot, just say, hey, can we talk tomorrow? Or maybe over coffee, if that's something that would help calm everything down. Speak from your own experience perspective and say how you are being affected. And this is really crucial, and we'll actually be talking about in the next couple of slides about using I statements as a way to portray your own perspective in a healthy and respectful way. And lastly, of course, avoid the cycle of escalation. It's never healthy to engage in a shouting match. One thing we like to recommend is that the louder they get, the quieter you get. And then if you get quieter, they'll have to quiet down in order to hear what you're saying. So if we move to the next slide, we're going to talk about being assertive through I statements. And so there are 3 parts to an I statement. The impact on you, so I feel this way, the other person's actions that affect you, and lastly, the request. So it'll look like, I feel frustrated and angry when the dishes pile up because it makes me feel like my life is chaotic. Could we please find a time to talk about a solution? And that is a really respectful and easy way to discuss a topic that potentially could be full of conflict, because these things can blow up if we're not careful. So that is 2 quick things, the active listening and using I statements, that can be really helpful in managing conflict. So if we go to the next slide, in review, we avoid conflict traps by responding with empathy and being a good active listener. Use your assertiveness to explain your position without projecting onto or blaming the other person. That's moving on to the collaborating corner of the graph. And lastly, make sure both parties feel heard and understood before you move on to problem solving. So that is just a quick overview of some of the things we talk about in conflict coaching. We encourage you to reach out if you want more discussion about this. There's lots of tools we have, but at this point, I'm going to move on to Jen from the York Region Community Mediation Services.
Hello, everybody. Thank you very much, Ben and Mary, for doing such a wonderful job explaining about the mediation program the process to the mediation program that we offer. So first of all, to explain a little bit, my name is Jennifer Lamb, and I manage the York Region Community Mediation Program up in York Region. Everything north of Steeles and everything south of Steeles belongs to the neighborhood group. The way it's sectioned is just geographic boundaries, what makes sense. So if your property is in Brampton, then you would call our sister organization in Brampton. If your property was in in York Region, you would call me. If you need to access additional mediation programs beyond the TNG or myself, I understand Mary has provided my address as well as my contact information. There, you'll be able to find my contact, my follow-up contact, and we can communicate, or I can refer you to the appropriate one. Or did you provide the website to the OCMC by chance? Mary?
Well, I have the York Region service. I did not put the website link, but I can put it in the chat right after this.
Yes, please do. Please do. So basically, any service that the TNG in the Toronto area would be offering for you in the landlord and tenant spectrum, we can offer all across the Greater Toronto area, all across Ontario. So I understand there might be some questions. So since Ben and Mary have already done such a great job explaining everything, if there are questions, we can answer it now. We can leave it that way.
Okay.
Thank you so much for your attention during this presentation. We will now address your questions. We will be answering questions previously received, as well as live questions shared in the chat function. If you are not able to ask a question today, please call our office during our regular business hours, and we will be happy to assist you. Okay, so I received a question in the chat. An attendee is asking if, can you share a template of a consent agreement for landlord agreement? So is there a template for an agreement between a landlord and a tenant?
Are you talking in the context of a final agreement, or are you talking about an agreement to mediate? There's a difference.
Yes. So, okay. So the attendee is saying a landlord and tenant consent agreement. So more or less something that anyone would be able to use.
Okay. Okay. So I will answer on behalf of Mary and Ben, if you guys don't mind. At the York Region Community Mediation Services, and specifically at that York Region Housing Mediation Services, we do not have any templates that we use, because we recognize that each mediation agreement is different, because each of the issues coming to this table, it's different. Therefore, it wouldn't make sense to pre-speculate what the parties would arrive at, what agreements they would agree to. Our mediators have their capabilities, whether it be a laptop or written agreement, that we can help you use key languages or certain words that help to make the agreement very fluid, very, explain it extremely well. And both parties, whether it be the two tenants or the landlord and the tenant, would sign it, and you would go from there. But the straightforward answer is there would be no actual template agreement. We do have mediation agreements, but that is an agreement to mediate, and the agreement to ensure all the information given, all the information shared remains confidential. If that's what you're referring to, you can certainly visit our website to access an agreement to mediate and the confidentiality agreement. I can put that website information in the chat room. Okay. Yep.
Yes, please.
All right. Let me do that right away. Screen.
Okay, so we will wait for more questions to come in the chat if anyone would like to ask a question. In the meantime, we have received a question for Carolina. Let's see. Carolina. So the question reads as, if I go through the payment plan process and receive a payment plan order from the landlord and tenant board, how quickly can I get termination of the tenancy if the tenant fails to follow the order payment plan? Can the tenant delete this process?
Well, since the order was based on an agreement, it should mention Section 78 of the Residential Tenancies Act, which will allow you to file Form L4 with the landlord and tenant board to notify them that you want to continue with termination of the tenancy because the tenant failed to meet the conditions that they previously agreed to. And this usually will result in the landlord and tenant board sending an order to both you and the tenant without scheduling a hearing.
Thank you so much, Carolina. Just to let everyone know, Mary and Jennifer have shared information about their website, and so people can access it's like a sample of the agreement, the mediation agreement that Jennifer was talking about. So if anyone is interested, you can look on the chat to find that information, okay? We also received another question. I think it's more for Carolina. This question reads as follows. What happens if I approach my tenant to discuss a payment plan, but they ignore me? Will the landlord and tenant board consider this?
Yes, they will. It's best to document your communication with your tenant. So you can send an email or a letter to explain your willingness to meet with the tenant to discuss payment plan options. Don't worry if the tenant ignores the communication or responds saying that they're not interested. If this does happen, you can just submit a copy of the correspondence to the landlord and tenant board as part of your hearing evidence package.
Thank you, Carolina. Okay, so I see another question popping up on the chat. I believe this is more for Mary, Ben, and Jennifer. It reads as follows. If there is a conflict between the landlord and a tenant, only the lawyers from both sides are talking. The parties are not deciding to resolve through mediation. Is it fair to send them a proposal to end the agreement mutually, as it serves the purposes of both sides? Who would like to answer?
I'm sorry.
So
I'm not understanding the question very well.
okay, so I'm going to reread it. So the question reads as follows. If there's a conflict between a landlord and a tenant, and they're both represented by lawyers, and the lawyers are talking, the parties decide not to resolve their issues through mediation. So the question says, is it fair to send them a proposal to end the agreement mutually? So I believe it's the agreement to end the tenancy, as it serves the purposes of both sides, I guess, since they're not able to, so the person says that he's referring to the N11.
So is it the lawyers, the two lawyers that are coming to the table to mediate, or is it the parties that are coming to the table to mediate? Because if it's a lawyer, then they would expect different information than it would be the two parties coming to the table. So to use it in a very, to use even more concise information, mediation is intended so that we don't have to involve the lawyers. It's a process that is friendly, that is catered specifically to everyday individuals using very simple languages that do not need the assistance of a lawyer to help you navigate, to help you understand the terms, the terminologies that are used, or any agreements that are reached. So if both sides, the landlord and the tenant, both had a lawyer or a paralegal representing them, they're certainly welcome to participate in the overall process. But as some of my clients in hindsight have said to me that, you know what, Jennifer, I didn't need my lawyer to be participating or to be present at the mediation because I could have saved myself that 3-hour worth of legal fees. So that's the reason why we try to make the mediation very accessible, very friendly, very simple for every individual to be able to access and to be able to understand without legal representation. If you had legal representation, that doesn't mean they can't participate. It just doesn't make sense at that point. Does that help answer the question? If not, please clarify.
I believe.
I'll be happy to take another stab at answering it through another way.
Yeah, I believe it does. It answers the question. Thank you so much. We had received another question. I believe it's more for Carolina again. So it reads as follows. What if my tenant and I cannot agree on a payment plan? Do I have to go along with that, with what the tenants are proposing?
No, you don't. So you're not obligated to agree with a payment plan that you don't think is reasonable. In a case like this, your matter would proceed to landlord-tenant board hearing, and the adjudicator will determine what they feel is best after considering all the information and evidence that you present to them. It is best to try to work something out with the tenant, but it's not always possible.
Thank you so much, Carolina. Okay, we have another scenario in the chat. So another person is asking if an N7 notice is not enough for the tenant eviction as the L2 application, even though the notice was served in a timely manner and evidence was provided and is as detailed as possible. I think the person is asking if mediation would work in this situation. If an N7, even though has enough information to provide to the adjudicator and maybe lead to eviction, but eviction is not granted, would you recommend mediation in this situation? I guess this question is more for Ben, Mary, and Jennifer.
So sorry. So a N7 is not enough for the tenant eviction, okay?
Yes, so even though the landlord believes that an N7 should be sufficient because the landlord prepared the notice and provided detailed information about what's happening, but that's not sufficient for the adjudicator to grant eviction. I believe that's what the person is asking, if mediation would be suitable in this situation.
So this is where my bias will come through and show. I think mediation is suitable in all situations. And to that extent, to this extent today, it's landlord and tenant issues that we're dealing with. So without a doubt, I think we need to take it out of the context and look at it from the view of the fact that mediation is giving both parties ownership and the power to manage and decide how they wish to have this conflict end. And if you go through the legal realm, without a doubt, it is very rights-based. It is about who is right under the law. And, depending on the evidence you're showing, depending on the rights that you have on your side versus the other party, one party is going to come out a winner more so than the other. And the less successful party at that point will either be, disinterested and not willing to engage anymore, or will take the extreme of being very opposed to the agreement that's been handed out by the adjudicator. Whereas mediation offers you that chance to say, you know what, this is a problem that we're both facing. How can we jointly solve it without the interference, without the intervention of the landlord and tenant board? And if you and I can come to some type of a resolution, we follow through with the resolution, that is the best scenario. Now, what happens if you can't? Well, with us at the York Region, up in York Region here, we provide you with a closing letter at the end, should you require it. And having that closing letter details that you've made the effort to participate in mediation, you've made the effort to come to a resolution, but unfortunately, it didn't, proceed through, it wasn't successful, or the conditions were not followed through by one of the parties. It definitely helps the adjudicator to know the goodwill, the good intent, and the good faith you had placed in trying to resolve it in its most amicable way. So I can say, with all my biases showing through, that mediation can only help. It will in no way affect your case negatively. Whether you decide to do mediation through any of the community mediation programs in Ontario, or that of the landlord and tenant board on the day of, which, yes, it is a shorter time frame, a shorter process itself, but they still manage to have results. So you must see some advantages to that.
Okay, thank you so much, Jennifer. So yeah, I think it definitely answers the question pertaining to this presentation, but everyone involved has explained about mediation. So yeah, I see a follow-up question from the same person, but I think, your answer pretty much answers the question. The mediation is suitable in all situations, and it doesn't affect negatively someone's case.
Mm-hmm.
So yeah, like we said before, if you have any other questions pertaining to a specific case that may not be related to mediation, please just call us during our business hours, and we'll be happy to assist you, since this presentation is more about general information, not about any specific cases. So yeah, I don't see any other questions pertaining to mediation or conflict resolution. Okay, so let's see. Okay, so that's it for the question period. Thank you to our partners and fellow presenters, Mary, Ben, and Jennifer. And on behalf of the Landlord Self-Help Center and TNG Community Services, thank you so much for attending this presentation about conflict resolution and mediation. We would like to remind you to please fill out a participation survey based on this presentation, and we'll look forward to seeing you in our upcoming presentation. Bye, everyone.
Bye.
Thank you very much. Please feel free to give us a call if you have questions.
Thank you.
Thank you.